Hello, good afternoon, and welcome to The Law. This is your Legal Light, and this is your Help Law. I'm Samson Lardy Anyenini, and this afternoon we are looking at prosecutorial errors. When you are placed before a court for having committed an offense, you are the accused. You begin as the suspect from the police station, and you become the accused person standing trial. There is one very essential document without which you don't stand before the court. It is called the charge sheet. Mistakes made on the charge sheet have cost some, particularly poor people. Some have been placed in custody. They have been unsuccessful at getting bail, only to find out later that they were not supposed to be at the police station or in the court in the first place. So they would have been put in custody for nothing, unjustifiably. So we are looking at prosecutorial errors. Some, in fact, may get the poor into jail. I'll be right back with my guest, one who has authored many books in the area of criminal law, to assist us with some education on the common errors that you are likely to find made by police prosecutors or even the Attorney General attorneys who take you to the court over a criminal offense. We'll be right back.
When they served him, they had served him with the charge sheet and brief facts, and then he got it to me. So when I read it, I realized that the only thing they mentioned in connection to him was the fact that he had received a motorbike after an alleged robbery. But contrary to those facts, he had actually been charged with abetment of robbery. So when I saw it, I felt there was a problem. So I had to, after they took their plea, I made a strong application for him to be discharged, because I felt that one, for abetment, it simply meant that he had facilitated or aided or done something in furtherance of the alleged crime that was committed. But right in their own facts, they stated a motorbike was given to him to sell after an alleged robbery, which I felt those facts did not support the charge. And I made that application. Unfortunately, the judge agreed with me, because there was no connection between giving a motorbike to somebody to sell after a robbery and charging the person for abetment of that robbery. And those were the grounds for which he was discharged. And from the weekend where he was arrested till the Tuesday where he was let go, he's become a free man. And but for our intervention, trust me, they would have remanded him like they remanded the other accused person. So sometimes these things, they happen a lot. The reason that sometimes we don't normally hear about them is because you see, from most of the courts, especially district courts and circuit courts, you have fewer lawyers going there. Now, most of the trials in this country actually take places in those circuit and district courts, but most of them don't have the money for the services of lawyers, and for them, they just take them. As a matter of fact, what actually happened in this case was the investigator had come to inform the prosecutor that all they were seeking was a remand. So, as a matter of fact, they were not actually coming to even take they didn't want their plea to be taken. They just wanted to come for a remand because they had exhausted the 48-hour rule and they felt like they didn't want to have problems. So that was the reason they were bringing them to court, so they could secure a remand and to do further investigations. So if I was not there, or if there was no lawyer, they would have simply taken an adjournment to say that they are going to do further investigations. Now, these cases, they happen a lot because, like I've said, there are no lawyers.
So that's one such example where prosecutorial errors could actually cost someone their liberty. And this is what happened in this particular case. Thankfully, the brother of the accused person was watching this show when we treated the topic how to access legal aid, how to access legal aid. The brother was watching the show, and the next day he managed to make contact with the lawyer you just saw a while ago, that is Sani Mahmoud Abdul Rashid, who has been on the show with us in the last 2 editions. They called him almost like at the 11th hour, around 1 p.m. thereabouts, when the court would be in a hurry to rise. And he rushed there and rescued this poor man. Otherwise, as he said, maybe by now that man would still have been in police custody or even prison custody, if you like, until another time. And if he's still not lucky, he could still be languishing in jail for something that he clearly ought not to be held liable for. And that's why this afternoon's discussion is important. So pay attention, join us as we try to help you to identify the common errors that are made, some of which cost particularly the poor. Because those who have money and can afford lawyers, this will hardly happen to them. They'll call their lawyer, and immediately their lawyers will know and put it to the police that what you're doing is absolutely wrong. You can't do that. So, joining us via Zoom from Siani, from Adum Legal Consult, is Daniel Krang. Daniel Krang is a lawyer and also an author, as I mentioned to you earlier. He has authored several books on criminal law in Ghana, and I'll share just a few of them with you in the course of our discussion. This is one of them, one of those books. I've been using this book for about 6 years or so now. Thank you, Daniel, for making time to join us.
You're welcome, Samson.
Great to have you. Good afternoon. So maybe we should begin from this point. And I know that you have a lot of these common mistakes or errors to tell us about and to give people the opportunity to assist them to avoid being unlawfully, as it were, kept in custody. But in this matter of the Republic versus Eliahu Dawood and Alihu Zachariah, where the Legal Aid Commission lawyer's intervention led to he gaining his liberty. When you look at the fact sheets, what can you say?
Thank you very much, Samson, and good afternoon to your viewers. In fact, when you sent the document to me, I read it and I felt so sad and sorry for the gentleman. What I gathered from the charge sheet is that somebody is alleged to have robbed another person who was on a motorbike. After the robbery, the alleged robbers took the motorbike and gave it to somebody to sell. And the one who took the motorbike to sell has been arrested and charged with robbery or abetment of robbery. He was not at the scene of crime. He was not said to have done anything to assist the alleged robbers, but he was charged with abetment of robbery. I think this was patently wrong and improper on the part of the prosecutor, to have done that. And what I realized is that the prosecutor who prepared this document simply did not appreciate the law on abatement, but he had presented it to the court. And what is sad in matters of this nature is that if you don't get a judge who is a master of the law, he would admit this fact and let this accused person go through full trial with the sad realities of he being on remand for a long time. I think it is really sad.
All right.
Really, really sad.
And even apart from being on remand, as you mentioned, the person could be on trial, going to court. You may have to go to court for a year. You may have to go to court for 1 year, 2 years, or even if you have gone to court for just a month, 2 months, or 6 months, that is enough financial, expense on the part of the person. And then yet, in the end, even if you are found not to be guilty, this is what cost would have come to you. So these common errors, why do you think they happen, particularly with the police prosecutors?
Thank you very much, Samson. We usually say these are errors. And when we say errors, we are implying that they are mistakes committed by prosecutors on the charge sheets. But Samson, I can tell you that some of these things we call errors are not really errors. Some are genuine mistakes because the police or the prosecutor doesn't know the law. But in other cases too, they are deliberate. They are really deliberate. Now, if we want to know some of the causes, I would want to mention that criminal prosecution is a very serious business that requires deep knowledge of the law and professionalism on the part of those who prosecute. Now, we realize that in Ghana, there are few lawyers working for the Attorney General or who are in the Attorney General's department. And so when it comes to the lower courts, particularly the district courts and the circuit courts, all the prosecutions there are being conducted by police officers or lay prosecutors, those who are not professional lawyers. And I can tell you that they cause a great deal of mess in these lower courts. Some of them do not understand the crimes or the criminal offenses that they bring before the court. Others do think that criminal prosecution is just anything anybody can get involved in. And so you see them messing up big time in the district courts and in the circuit courts.
Right.
And when you go to the remote parts of Ghana where there are district courts, my brother, you can understand that lawyers don't go to those parts of Ghana. And so they do just what they want there. The prosecutors do what they want. And one sad...
Please go ahead.
Hello.
Go ahead.
One sad thing I observe as a lawyer when I go to particularly courts in the remote areas is that most of the magistrates there are career magistrates. They are
exactly the point I was coming to.
And so, excuse me to say that some of them, their appreciation of the law and procedure is not really commendable or appreciable. I don't want to use the word.
Yeah, because now, they are not trained lawyers.
They are not trained lawyers.
Right.
And so they rely most of the time on what the prosecutor presents. And so they listen to the prosecutor. The magistrate will do just anything that the prosecutor says. And that is really a problem.
Yes.
So
but it must be said from the outset that they are excellent magistrates and judges. Some are quick to see these errors by themselves, so that even when you are presented before them and you don't have a lawyer, they will see this and sometimes they actually berate the prosecutors and tell them how wrong they are, correct?
That is exactly so. But let me also add that it is not only unprofessional magistrates or career magistrates. There are some trained judges who are professional judges who fail to see some of these basic errors. I was in a court a few days ago. A prosecutor had presented a criminal case of breach of a fraudulent breach of trust. And this was a pure civil engagement between the complainant and the accused person. The complainant had given money to the accused person to buy some items for him. The first tranche of money he used to buy the items. Second tranche he used. Third tranche he used. The fourth tranche, the accused person says that he gave the money to the farmers, but the farmers had not produced the items. And this gentleman was in the court on a charge of fraudulent breach of trust. And there is nothing you will tell the judge to convince him to just understand that there is that line between civil cases and criminal cases. So I asked the judge, my lord, so when will breach of contract be called breach of contract? I mean, and that caused a lot of laughter in the court. So, Samson, this is a very serious issue we're discussing this afternoon.
Right.
Because I always say that every one of us is a potential accused person. Every one of us is a potential prisoner. And so when we are talking about matters or errors or misconduct that police officers and state attorneys do, which get people in jail, I think it is a matter that all of us should really concern ourselves with.
You're right.
And yes.
Daniel, I'd like to start with you from this point. I'm reading from page 229 of your book, Criminal Prosecution in Ghana, Practice and Procedure. And I must first confess that I have used this to my benefit and the benefit of my clients many years ago, and I was so excited. And so it's a portion that I've actually, marked. When you
I'm glad to know that my book has been that useful.
Right. When you spoke about the charge sheet, you said in criminal law, a charge or count is a statement accusing a person of an offense upon which the accused person will be tried. Without a charge properly laid, the trial of an accused person is improper and unsatisfactory. And I note that while you are saying all these, you are not just saying your own things, but you are backing it up with legal authority. So the annotations, the footnotes are there. What exactly is this charge sheet, which you say where there is not a proper, the charge is not properly laid, the trial of the accused person is improper and unsatisfactory?
Thank you, Samson.
Is the Zoom frozen?
We know that we don't just hold a person's hand and before we bring a person before a court to be tried on criminal charges. There must have been an allegation or a complaint against that person with the police. The police must have arrested or invited the person to the police station. An investigator must have been assigned to conduct investigation into the allegation or the complaint, and grounds, legal grounds for that matter.
The Zoom is, we have a bit of an unreliable, connection, but it should get stabilized quickly so that we get back to Daniel. Right, great. Daniel, you are back.
Right, thank you very much for getting me back. Now, when the police have found that the basis to lay a charge sheet. Now, the charge sheet is a document, a legal document, that contains the title of the case. And the title of the case is always structured as a contest between the Republic of Ghana and the accused person, or the person who is alleged to have committed a crime. So you would always see the Republic versus Akwesi Nketia. That is how the title ought to be. Now, after the title, you immediately see statement of offense. And the statement of offense is that portion of the charge sheet that names a particular offense, say rape or defilement, contrary to. Then the section which is alleged to have been violated will be stated. So that means that before a person can be said to have committed a crime, it must be said that he has violated a written law, And so that written law must be referred to in the statement of offense. Now, immediately beneath or under the statement of offense is what we call particulars of offense. Now, the particulars of offense is the area where the prosecutor will mention the name of the accused person and indicate that on so and so date, you did commit this particular offense at this particular time or at this area. So the purpose of the particulars of offense is to provide sufficient details of the commission of the crime,
right,
so that when one reads it, one would see the statement of offense and sufficient details of the commission of the crime.
And
so
what you mentioned, the imperative is the Article 19 of the Constitution. Nothing is an offense unless that particular, offense has been, as it were, defined, written in a written law, and the sanctions also prescribed. Right. Okay.
Yes.
Right. Now,
let me say this. The reason criminal procedure requires that the statement of offense should refer to a particular provision of a written law is that we as a country have abolished common law and customary law offenses in our criminal jurisprudence. And what that means is that until you can prove that somebody has violated a written statute or act of parliament, nobody can be said to have committed a crime.
Great.
And so, yes, and so when you are bringing somebody to court on grounds of commission of a crime, you have the duty to indicate that there is a written law which that person is alleged to have violated. Yes.
Great. Now, how important is the information on the charge sheets? How important is that information?
Thank you. Now, the charge sheet, more or less, is a complaint sheet. When I say complaint sheet, it is that sheet or that paper that informs both the court and the accused person himself that this is what you have done. And what you have done is against a written law in Ghana.
Mm-hmm.
And so one important thing about the charge sheet is that it informs the court, it informs the accused person, it informs the accused person's lawyer, it informs everybody who is concerned with the criminal proceedings, so that we will know exactly what the prosecutor is talking about.
Right.
And another important thing is that once it has informed the accused person, it gives the accused person and his lawyer the opportunity to prepare a defense.
Great.
You cannot prosecute a person or try a person without giving the person adequate information about the person's offense.
So
the purpose is to
right.
inform, yes.
So the first line of common mistakes, and I'm still at page 229, where you say that where it appears to the court that the charge is defective in form or in substance, the court has the power to order that the charge be altered. So what you're saying here is that there's a possibility that the charge can be defective. What does that mean?
Thank you very much. Now, when we say a charge is defective, it means a lot of things. And one is that when the charge is not said to have been a violation of a written law, obviously, it is even unconstitutional.
Right.
Yes, it is unconstitutional in the first place. And another is that when a charge is brought against a person and the charge tells a story of a purely civil wrong, that is also a very serious, defect. so that the prosecutor will narrate that the complainant gave money, they entered into a contract to supply cashew nuts. The person supplied some and could not supply all. And so he is here on defrauding by false pretenses. I mean, this is very funny, you know, and it happens in our courts often. I have always said that the criminal law is a very serious aspect of our law that cannot be so, flippantly engaged. You cannot engage the criminal law to enforce civil rights. So when you see that the law is being used to enforce a civil right, which is not criminal, it is a defect that a judge must open his eyes to. And in other cases too, you realize that there are a lot of typographical errors on the charge sheet. My brother, let me say that in court, lawyers deal with words, we deal with phrases, we deal with expressions. And so you don't take any error as a mean thing or as something small. Me, when I see an error on the charge sheet, I exploit it like a gold mine. And this is because one word can make a difference. Now, when we know that every offense has two elements, the physical element, which we call actus reus in Latin, and the mental element, which you call the mens rea in Latin. Now, when every criminal charge is contained in a charge sheet, the allegation must allude to the fact that these two elements exist. So when you look at the statute book, offenses like murder, manslaughter, stealing, fraud, and all those, you realize that the lawmaker intentionally includes words like a person who willingly, who intentionally, who knowingly, who deliberately. All these words are not there for nothing. They are there to let everybody know that those offenses must have been committed deliberately, intentionally, knowingly, and with that kind of state of mind. And so when the prosecutor brings a charge that requires that express mental state, and they don't include it in the first place, it is a non-starter.
Right.
So that when you are charging murder and you don't include the word intentionally killed, you have failed in advance. And if I'm a judge sitting and I see that a prosecutor has said, you, Kwesi Mensah, on this 26th day of November 2022, you did kill one Fuzeni in Sunyani, you have failed because you did not include the word you did intentionally kill. Now,
so maybe in that circumstance, what they ought to be doing is manslaughter rather than murder.
That even cannot pass.
Okay.
For manslaughter, because manslaughter is murder reduced to that. So it is either the person caused the death negligently. If the death was caused accidentally, it is no crime at all. And so prosecutors must learn that before they lay a charge, they should go to the law, read to know whether the elements include a mental state, a guilty mind, so that in framing their charge, they will do the proper thing.
But you see, you had mentioned,
you are just down.
Right, you had mentioned that some of these errors are genuine, whilst others are deliberate. So that, for example, where you stated where people try to use the criminal law to enforce, commercial, as it were, engagements or contracts. We know situations where the deliberateness could arise from the fact that the police officers may have an incentive, they have a benefit. I engaged in a situation just this week when a clear commercial matter, the police is sort of helping somebody, and the assurance is that the person who is brought to them is granted bail, and he's supposed to pay the money and pay an extra amount directly to the police. So they have an interest. If that doesn't happen, then they will take a charge, you know, haul the person to court, knowing for a fact that this is not a crime. So sometimes there is a certain incentive.
Yes, in fact, Samson, as for this matter, the least said about it, the better for all of us. Now, when we talk about police officers expecting incentives to criminalize purely civil transactions, it is commonplace. It is all over the place. Now, this I call bribery and then corruption, which really occur at the police station almost on a daily basis. Some police officers think that every docket that comes to them is business from which some money must be made. And so the person is arrested and they begin to give attitude to the suspect, indicating that if you don't pay, you're not going home.
Yes.
And sometimes too, the complainant will pay the police to say that go and arrest him, I'll give you this percentage of the amount. And when the money is promised that way, the police become overzealous. Overzealous prosecution means that the police think that they are the victims of the crime because they have something to benefit. And this is really serious because it involves human rights. Now, when a police officer takes money, they begin to do a whole lot of things. One of them is that they embellish the facts of the case to make it look as if this person is the worst criminal ever. So a matter that is so simple, that has no incriminating, aspects, the police will borrow a lot of jargons. I remember I did a case recently, in fact, I'm still doing it in a district court. The case is that the complainant and my client, who is the accused person, fought at the farm over a piece of land. And so my client was brought on a charge assault. The police had written that my client beat the woman until she collapsed and she was rushed to the hospital from the farm. So when the woman got to the witness box, I asked the woman, on the day of the assault, you walked back home. Is that correct? She said, yes, I walked back home. Then I asked another question. On the day of the assault, you walked to the hospital yourself to be checked. She said, yes, I walked to the hospital myself to be checked. Then I asked another one. So do you want this court to believe that as a result of the alleged assault, you did not collapse? She said, I never collapsed. Meanwhile, the police had written in the fact that the woman was beaten till she collapsed, and she was carried shoulder high to the house, and she was rushed to hospital. My brother, you ask yourself, where did the police get these facts from? If not because they probably had some inducements and benefits to enjoy.
Interesting.
I think it is very pathetic, very pathetic.
Interesting.
And,
so, I wanted us to look at...
One danger about this embellishment is that they influence the judge in consideration of bail or certain bail conditions. So the judge at the pre-trial stage will tell you, counsel, you are asking for bail. Look at the facts. The police are saying that your client beat this, helpless woman, so she collapsed and she was rushed home. And you think this wicked man, we should grant him bail? My brother, I know that facts contained in charge sheets really play on the minds of judges.
Right.
And so when the police officers embellish them or include things that are unwarranted by the situation, I think it's a real source of worry.
And like in the case we just looked at, they had gone to the court just to seek a remand. They were not interested in anything, and they would often say, investigations are ongoing.
Under investigation.
Exactly. So don't grant the person bail. Now, what are some of the common errors that you think we should pay a lot of attention to?
Well, let me name a few of them. Some of the errors, which I also call misconduct on the part of police officers, which I think all of us must pay critical attention to. Now, the first I'll mention is extortion of confession statements from accused persons or suspects. What I mean by extortion of confession statements is that when a person is picked up or arrested by the police have already received complaints from the complainant. And they believe that once the person has come to lodge the complaint, he is right. You know, when you read the book of Proverbs in the Bible, it says that the one who goes to court first is not right, or is not always right. It is in the Bible. So the police should know that the person who runs to the police station to make a complaint is not always right. And so when they are approaching the matter, they should approach it with open, unbiased, and fair mind. They shouldn't go as if the person has committed a crime and so they are descending on him to beat him up and all that. And when they have picked him up, they will tell him to give his side of the story. Once his story doesn't, conform to what the person has already come to say, they will tell him, my brother, tell the truth or be beaten. Now you ask yourself, what is the truth they are talking about? Are they measuring the truthfulness of the suspect's statement against that of the complainant?
Or some evidence they have?
Or some evidence before them. When they are taking statements, they should allow the suspect to narrate his side of the story. And they should just write that. And when they say you should tell the truth and you're not telling the truth, they will beat you and let you go through all sort of physical torture and mishandling, just to let you say what they want to hear. And by that, they get people to confess to the crime. And let the public who are listening and watching us now understand that every statement you give to a police officer is a piece of evidence that will be used against you tomorrow. If you are a Roman Catholic member and you go to your priest to do confession, you can tell everything you have done because they are presenting it to God, who doesn't prosecute. But if you are telling a police officer something, you must be careful because whatever you are saying is going to be used as evidence against you tomorrow in court. And so you don't go there and talk as if you are talking to a pastor or some man of God somewhere for forgiveness. Now, apart from confession statements, one serious thing that happens at the police station is that the police will write their own facts and get the suspects to sign or thumbprint. So that in cases where the suspect is an illiterate or is unable to read and write in the English language, the police will write their own story and get these poor people to sign. And once you have signed, when you go to court, the judge will say that once you signed, you meant the content. So I will humbly appeal to our judges that they should take confession statements with a pinch of salt and with a lot of caution.
But there are judges who are alert and aware and say that they will not eat of the poison fruits. So if the police, forced the confession from you, or they made you some promises, that if you say it this way, we'll grant you bail, or if you say it this way, when we go to the judge, we'll do things this way and you'll get your liberty, only to turn around against you. There are judges who will clearly see that they are led and they will say that they will not eat of the poisoned fruit, so that there will now be
that is very encouraging.
It becomes necessary for the mini trial to determine whether the statement was a voluntary one, whether there was an independent witness or not.
That is very encouraging to know, Samson. Now, if I should proceed, I want to mention that another serious thing that the police do often, which really affects the liberty of the individual, is that they would advise you, don't engage a lawyer in this case. This is a very simple matter. I remember I was going to the police station to get bail, and the police were seriously advising my client that, Master, this matter, dear, it doesn't require a lawyer. We will help you. Let the public understand that the police officer is like a butcher at the slaughterhouse. When he has tied your neck with a rope and pulling you to the slaughterhouse to kill you, you don't take his advice. because the person is going to kill you. And he's advising that don't get a redeemer or somebody who will assist you. I believe that the right to a lawyer, especially at the pre-trial stage, the investigation stage, is very crucial. And so our police officers should refrain from advising suspects against going for, lawyers.
And we need to say this is very important, because at the time when you are being invited by the police or you are being arrested by the law enforcement and you need to give your statement, it's very important. Like Daniel Krang had just said, that every piece of information that you give to the police is potential evidence to be used against you. Therefore, be careful.
That is it.
If you have access to a lawyer, try and reach out to them, because you are entitled, according to the Constitution, in Article 14, to have that and to have them help you. Police officers, there are some of them too who are very professional and will assist you to know that what you are doing, these are the consequences, and state the facts as you know them. Don't allow any pressure to be upon you, and so on and so forth. People go to the police station, they are frightened already. And once they are being told that if you do this, you get bail or they'll throw you in, then they are in a hurry to write something that they may have been dictated to. And then later, you are now going to look for a lawyer. Sometimes it becomes a bit late in the day when you do it that way. Thank you very much. Daniel, please continue.
Yes, thank you very much, Samson, for that wonderful one. Now, let me add that another serious error, or what I call a misconduct on the part of prosecutors, is when they induce accused persons to plead guilty. When they are preparing the person to court, they will tell the person, when we go and the judge asks you whether you are guilty or not, say you are guilty. If you say you are guilty, all of us will help you. The judge will be lenient. He will have mercy on you and all that. I believe that whether a person should plead guilty or not guilty must be freely done. The person must be left to think through the situation and see whether he is guilty or not guilty. And when you go to the courts and you get to know certain cases to which somebody has pleaded guilty and the person has been sentenced, you realize that it is just, not proper. So a police officer should not tell an accused person to plead guilty. You allow the person to engage the lawyer will advise the person. If the lawyer thinks that this case is a helpless one and that you must, plead guilty, you can do that conscientiously. But if you are being induced, sometimes the prosecutors will give a lot of promises. When you plead guilty, I will not talk. I will tell my lord to release you. Now, let the public understand that a plea of guilty amounts to a confession or,
admission.
You are saying that you are guilty. Yes, it amounts to a conviction. A plea of guilty, when accepted by the court, amounts to a conviction. You have convicted yourself. And so you have to do that advisedly. Don't just listen to the prosecutor and plead guilty. That is another one.
But Daniel, we hear a lot of these stories in motor offenses with drivers, where the drivers, tell you that the police advice was that this offense, if you are found guilty, the amount to be paid is a small amount. You don't want to go to court today, go to court the next day, wasting everybody's time. So when you go, just plead guilty, and then we'll help you out, and the judge will give you a small fine. You pay, and you are gone. Sometimes, is that really a bad advice for the police to give to suspects?
Something, not in all cases, but my belief is that people should understand that criminal trial is not a game or entertainment in which you engage joyously. No, a criminal trial is a serious business that involves a judicial inquiry into whether one person has committed a crime or not. And so if you are an accused person, you don't have to rush to short-circuit it. You don't have to rush to end it because you think you don't want to go through the drudgery of a full trial and all that. Of course, if there are reasons and basis for you confessing and pleading guilty, nobody advises against that. But as a criminal law lawyer, my experience is that I don't advise my client to plead guilty, because even when your guilt is like as clear as the heavens, some technicalities may work in your favor tomorrow. You never know. You never can tell. You know, we have done a lot of cases in which, from the onset, the guilt of our client was just as plain as a white paper. But in the middle of the trial, in the course of it, you display some gymnastics, and then you get your way. So, as a lawyer, I would not say that a suspect should always try to plead guilty and you know, end it all. No, they should not.
Okay.
And you know, Samson, one thing about pleading guilty is that
wait,
lawyers know that
when you say gymnastics, I suppose that, I mean, well, just for the fun of it, but what you mean actually is that, for example, but according to the law, if someone makes an accusation against you of a criminal wrong, by law, it is their job to prove your guilt. So if you go to court,
that is it,
and you start the process, you have no obligation to prove that you are not guilty. It is their job to prove that you are guilty, so that there's a first round of the process where if they fail to indicate in fact that you are guilty, a court could let you go on the fact that there has been no case for you to answer. So I suppose this is what you are saying.
I mean, by gymnastics, what I mean is that, you know, many great cases fall on the altar of cross-examination. When the complainant and his witnesses are subjected to the crucible of cross-examination, their cases usually break down. And so when we haven't gotten to the stage where your lawyer will mount and then present your side of the story or ask questions, I believe you don't have to rush to admit guilt.
Yes. So the advice is don't rush. But the truth is that there are times when we see that our clients are in fact guilty and they have also confirmed their guilt, and the part of the duty of a lawyer is to help them through that process, to plead guilty and to mitigate so that they don't get a hefty sanction.
That is it, Samson.
All right.
Now another one, which is very dear to me, is overzealous prosecution with hostility. You know, when we say prosecutorial hostility, it is where the prosecutor takes the criminal prosecution as a warfare. Now, let me say that criminal prosecution is not a warfare. It is an enlightened procedure that involves rules, regulations, procedure. So a prosecutor should not be seen as engaging in a warfare or personal banter with the accused person. They get emotional and trying to, you know, pour everything out as if it is their own cases they're conducting. Of course, a prosecutor must do his case with all the zeal he has, but certainly not being unnecessarily hostile to the accused person. And some of these things, sometimes the prosecutor will routinely oppose bail for no basis, especially when you go to the courts where some police prosecutors are conducting the trial. Some of them will, after you have made an application for bail, will just stand up. My lord, I pray that you remand the accused person. Then the judge will ask, Mr. Prosecutor, what are your basis for saying this? He said, my lord, this person is a very bad person. Even everybody knows in society. You see, these are matters that are not meant to be placed before the judge at that early stage of the trial. So if a prosecutor does not have any reason in law or in fact to oppose bail, they should not oppose bail.
Good.
Remand is a serious infringement of the right of an accused person. And I am doing a case for a police officer the way his own police officers are behaving. Then he said, my brother, I am very sad. And I said, why are you sad? He said, the way my own police officers are behaving. Then I said, now you know that the law can bite even the one who is using it. So please, everybody, as I have said, is a potential accused person or prisoner. And so we should not routinely oppose bail when there are no legal basis to do so. And related to this, Samson, is what I call ambush litigation, ambush prosecution. I've already stated that criminal prosecution is not a warfare. And so police officers should approach it, or prosecutors should approach it with open mind. And they must behave as ministers of justice. I think when you read the book, you will see that I refer to prosecutors as ministers of justice. Their only interest in the criminal trial is to ensure that justice is done, and not to get conviction at all costs.
Hold on, Daniel. When you said, when I read your book, is it this one you are referring to, or
the one you have before you?
Okay.
You know, I've written about 9 books or 8.
Yes, let me just introduce to you some of the books that Daniel has authored. And as you can see on the screen, the book I'm just holding is there. There is also the one which is Jury Trial in Ghana by Daniel Krang. You will also see Theoretical Basis of Criminal Liability. You see Inchoate Offenses. Actually, that's the volume 2, Inchoate Offenses in Ghana. You see Criminal Offenses and Defenses in Ghana. Then you see Conflict of Laws as well. That's not all. He has Criminal Law in Ghana, and I think a few others. All right, so Daniel, we are wrapping up now. Finish up on the point that you were just making. And Daniel is based in Sunyani. He's with the Adum Legal Consult. Yes, Daniel.
All right, Samson, by way of conclusion and wrapping up, let me say that criminal prosecution is a very important business in our criminal justice system. And all the players in the criminal procedure or proceedings must play well their roles. And I would advise prosecutors to be disinterested and impartial in bringing people to the court. You know, prosecutors exercise a wide range of prosecutorial discretion.
Right.
They have the discretion to say we are going to court or we are not going to court. They have the discretion as to what charges they will lay. They have the discretion as to which witnesses they will call. And sometimes what is very important is that the police will not call the witness who they think will not favor their case and will favor the accused person's case. When you do that, we say you are withholding evidence and it is a misconduct, prosecutorial misconduct.
Right.
The police will suppress facts and evidence that are not in their favor. These are all wrong and improper. So I'll conclude by saying that criminal prosecution is a serious business and everybody involved, defense counsel should prepare well. Sometimes when you go to court sometimes and you listen to a defense counsel presenting a defense, you realize that this lawyer is the reason his client is going to jail. So I humbly plead that when we have a case as lawyers, we must take the case as somebody's life. Somebody has children, wife, family in the house, and his life and liberty is in your hands as defense counsel. You cannot take it lightly. You must attend to that duty with all seriousness and preparedness so that you can defend your client and defend them very well.
Right. For all of you, particularly lawyers who are asking where you can get the books that have been displayed, if you look at the flyer, you see contact lines on those flyers as well. We will continue with this discussion again. So join us again next week for yet another installment, or we will give you a date for the next installment of looking at prosecutorial errors. Our friends in the police, some of them are already reaching out and saying that some of your, you call it your accusations at them are very serious, and we will organize it nicely and see if we can get some of them also in here to demonstrate from their point of view what it is that leads to some of the things that they do. A lawyer colleague says that he's enjoying Daniel Krang's submissions, and he says, I have actually snubbed my EPL to listen to him. Tell him kudos to him. Thank you very much. Daniel, once again, Daniel is lawyer and author of legal text, particularly criminal law books. And he is with Adum Consult, Legal Consult in Sunyani. That's where he's based. So Daniel, thank you so much for your invaluable service. We will certainly have a part 2 of this discussion. Thank you all very much. This has been The Law. It is your legal light. It is your help law. I'm Samson Lardy Anyenini. Join us again for the second installment, where we'll open the phone lines for you to tell us your stories about some of the encounters you have had with law enforcement and get answers to them. Have a good afternoon.